We can do. All right, we're back in session. Our second case today, Universal Property and Casualty versus Gonzalez and Cuevas. The attorneys could please introduce themselves for the record.
Good morning, Your Honors. David Noel on behalf of the appellant Universal.
Morning, Your Honor. Michael Cassell on behalf of the appellees, Nelson Rodriguez and City.
All right, and how much time would you like to reserve for rebuttal?
5 minutes, please.
Okay, Counsel, you recognize.
May it please the court. We're here today to resolve a pure legal question under this court's de novo review. And that question can be boiled down to, based on all three of the briefs, the following question. Can an insurer waive the statutory and contractual ACV provision in the insurance contract by denying coverage? And the answer to that is no. Now, there is a conflict between the DCAs on this particular question. The first DCA to issue a case directly addressing it was the third DCA in the Citizens versus Tio case. And they said, yes, that provision can be waived. The contract can be rewritten by denial of coverage. The fourth DCA came next in the Qureshi case, and they said, no, we can't use waiver to rewrite the insurance contract, and they certified conflict with Tio. Most recently, we had the second DCA issue their Brito opinion, and in that opinion, the second DCA agreed with the third DCA and Tio and said, yes, we can use waiver to rewrite the insurance contract, and Brito did certify conflict with Qureshi from the fourth DCA. And then even more recently, the second DCA issued the Weston case, which also followed Brito. So there's that conflict in the DCAs, although it is important to note for the second DCA, there's a tension within their own case law, because back in 2016, the second DCA had issued a case of Citizens versus Amat, which we do cite in our briefs. And that particular case held, and this is a quote from Amat, Citizens' determination that the homeowner's claim for damages was not a covered loss under the policy did not change the scope of coverage that it had contracted to provide any more than it eliminated the policy deductible or the policy limits. And the issue in Amat was whether in a sinkhole claim, the requirement that subsurface repairs must be entered into contract for by the insured before they became payable. The argument was that Citizens waived that requirement of a subsurface repair contract by denying coverage.
So I'm glad that you went through an overview of these companion cases, because I have some questions related to the contract that's involved in this case compared to the insurance contract that was involved in some of those other cases. So is the contract subject to these instant proceedings distinguished at all from the contracts in Tio and Brito?
So the contractual provision regarding ACV is the same provision because it does come from a statute. It's in all of the homeowners policies simply because the Florida legislature required it in 627.7011. But we can't just read that in isolation, of course, in the policy. This policy has a lot of different policy provisions, and it also has what's called a loss payment provision, which specifically contemplates that payment would be issued after a final judgment from a court. And it says we would issue payment 60 days after we receive your proof of loss and there's entry of a final judgment.
So in this instant contract, what is the provision that would require an insured to repair the property before being entitled to the full cost of the loss in a case where an insurer breaches the policy itself?
So it's the loss settlement provision, which says that we must initially pay actual cash value, and then we will pay the additional costs of performing the repairs.
So doesn't it say covered property losses are secured?
It does, Your Honor, and that's what the Brito case pointed out. But we did file a supplemental authority, a federal case called Polly, and it sort of points out, again, regarding Brito, that if you only treat the contract as giving a provision to pay for covered losses, then how are uncovered losses paid? Are we removing everything from the contract? Does that mean the deductible is now gone, the policy limits? You can't just limit the payment provision in the policy to a claim where the insurance company initially accepted coverage.
So is it Universal's position that the loss settlement section of the instant insurance contract, does that constitute a coverage limitation?
Yes, absolutely, Your Honor. It is a coverage limitation, and that flows to the Florida Supreme Court precedent there's multiple cases from the Florida Supreme Court that provide guidance to this court. And the first one is the Manor House case, Citizens versus Manor House, where the Florida Supreme Court held that the contractual amount due to the insured is the amount owed pursuant to the express terms and conditions of the policy.
So I'm looking at the law settlement provision here, and I'm looking at, first, when we're talking about buildings, screen enclosures, whether it's coverage A or coverage B, we're looking at replacement cost. And then it goes into some subparagraphs and looks at, how particular payments are going to be made. Wouldn't you agree with me that the law settlement section just prescribes how and when the payment of covered losses is to be divvied up?
Your Honor, I would phrase it differently than that, because the case law defining the distinction between a forfeiture provision and a coverage provision, it does include language that says a provision that delineates the dollar amount of liability is indeed a coverage provision. And that's exactly what this provision does in the contract. It delineates the dollar amount of liability. Do we have to pay the ACV amount, which is lower, or do we have to pay the RCV amount, which is higher? So that brings it within the category of a coverage provision. And also, if we think about the definition of forfeiture provisions, it means that you initially had coverage for a loss and then you lost it because of something you did or something you didn't do.
So along the lines of that argument, you taught us, at least in the brief, that it's Universal's take that TO kind of got it wrong, right? And you cite to the Manor House case. What was the question that was specifically certified to the Florida Supreme Court in Manor House?
Manor House was regarding whether extra contractual damages could be recovered because they were contemplated by the parties entering into the insurance contract. And the Florida Supreme Court said, no, you can't get extra contractual damages. I think it was lost rental income in that particular case. And the Florida Supreme Court came down and said, we go by what's in the policy. Your damages are part of the insurance contract.
So in the instant case here, are the damages claimed by appellees extra contractual or beyond anything the contract actually provides for?
They're extra contractual in the sense that no repairs have been made. So they're claiming damages, and they did claim damages at trial, and the jury awarded them for unperformed repairs.
But I think now you're getting into maybe some of the equitable doctrines that have been discussed in TO and Qureshi and Brito. Isn't there an equitable component to this as well? I mean, I'm a trial judge in Seminole County right now for a family of husband and wife, 3 kids. It's $100,000. You have to have in combined income to be living in Seminole County as a family. If we expect insureds to have to pay the cost of this stuff first, aren't we creating a situation where it's impossible to defend against a breach claim?
Well, no, Your Honor, it's not the case, because the breach claim can be for actual cash value. So the insured in a denied claim like this particular case could sue the insurance company and recover actual cash value damages. So there's no blockage or barrier to them filing suit. It's just a question of what damages are you contractually obligated to. And if you haven't yet made the repairs, you're obligated to actual cash value. But it doesn't mean you have to pound sand or you don't get anything. That's not the case.
So is Universal asking that we take a closer look at Qureshi and fall in line with maybe that logic?
Yes, Your Honor. Qureshi decided the issue correctly, and so did the Amat case from the second DCA, which came before these more recent cases.
So with Qureshi, are there any facts that are specific in Qureshi that would distinguish it from, for example, the holdings in TO or Brito, or the fact pattern that we have in this particular case?
So Qureshi, there was a payment issued on a mold claim. It was the mold limits for $10,000, but the water damage claim, nothing was paid on that particular claim. So the facts are not identical, but what Qureshi essentially holds, and it comes from Florida Supreme Court precedent, especially the Doe case, is that an insurance contract cannot be expanded by waiver or estoppel. And that's exactly the case here. We have a provision that delineates how liability is going to be determined, how damages are going to be determined, and to allow recovery for unperformed repairs and for matching costs and for damage that may happen in the future. It's estimated, but we don't know if it's ever going to actually occur during the repair process or if the repair process is going to take place. That's an expansion of coverage. And the Florida Supreme Court case law and Qureshi tell us that that's not something that can be done through waiver or estoppel.
But it wasn't an important consideration for the fourth district related to the fact that in Qureshi, the homeowners already sold the home. I mean, they didn't even have that house, right?
That's correct, Your Honor. That was an issue in the case that sort of closed the door permanently on replacement cost value, but it didn't really affect the analysis of can we waive the actual cash value provision. It was just an issue of, okay, replacement cost value, it's not something that you can get under certain circumstances in this case because you did sell the property. So you can never make those repairs. In this case, if the repairs are made with an actual cash value recovery, then replacement cost value would be available under that contract. And it does flow back to the Florida Supreme Court, like I mentioned, Manor House and the Doe case. And in addition, the Florida legislature, because up until 2010, 2011, actually, prior to 2011, that statute 627.7011 always required the insurance company to pay full RCV, regardless of if repairs are made. You had to pay everything to replace this damage potentially in the future. So in 2011, the Florida legislature amended that statute and completely changed the language, which is why we have the ACV provision in the policy now. And it changed it to require initial payment of actual cash value and then any remaining amounts necessary to perform such repairs as work is performed and expenses are incurred.
But I mean, jumping back to the statute, subsection 3A, I mean, the plain language, for a dwelling, the insurer must initially pay at least the ACV of the insured loss. Here we're in a situation where there's an alleged breach. So how does that impact your argument?
Well, Your Honor, we still reach the same end result of an insured loss or a covered loss because that's what the jury told us. So it's not that we're going to focus on was the claim denied or was the claim accepted. We're going to focus.
But go back to the statute.
Yes.
You're answering this question as though there wasn't a denial. The statute clearly seems to be indicating that there is a time when the insurer has to decide whether you're going to pay or not. And then you can go actual cash value. You're wanting to jump and say, you've got to go all the way to the end when a jury has done this, and homeowner, you better have gone out and determined what the replacement cost value is. You're not going to get an actual cash or reverse that actual versus replacement. That's your position, is that the only way you get there under this statute is to go all the way to a jury trial, and then you get to go back and have your cake and eat it too.
I would frame it slightly differently, Your Honor, because there's nothing in the statute or the legislative history or the contract that says this provision goes away if the insurance company denies coverage.
But we're not going to start talking legislative history and getting into that, but we all know what was happening back then is homeowners were taking the money and going, thank you very much for the actual replacement value, but not doing anything to actually repair their house, and then somebody else is coming in and nothing was ever done. That was what was driving it, and that's kind of public knowledge, but we're not going to go examine the legislative history. We have the language that Judge Brzezinski just read to you has clear indications that you expect the insurer to make a decision then. And you didn't do that. So why should a homeowner then go to trial and have to ask for something other than what their replacement, their actual damages are?
Well, because, Your Honor, until the repairs are actually made, those expenses aren't incurred and the damages are the direct physical loss. So we're not saying the insured can't recover for the direct physical loss. That's what actual cash value is. You just have to depreciate it, and it can't include any matching costs. So there's no block to the insured recovering damages. It's just an issue of what is the measure of those damages, and that is a coverage provision under the policy that can't be waived. Now, also, Your Honor, it's important to note a distinction between this case and all the other case law, and that's that the denial here was on post-loss obligations for lack of cooperation, failure to provide documents, failure to sit for a recorded statement. The denials in Brito and Teo and Weston, those were on coverage. This loss is not covered. You know, Weston, it was a roof replacement. Roof replacement's not necessary. In Brito, it was the loss is not covered under the all risk policy. None of those were denials of coverage for post-loss obligations. And that's an important distinction because the post-loss obligations are entirely within the control of the insured. So if we're going to say an insurance company denies coverage on post-loss obligations because the insured didn't cooperate, and now the insured can go to trial and collect a higher amount of damages, isn't that sort of giving a perverse incentive to not cooperate and get your denial on that specific type of issue? Ensure there is a denial and the insurance company doesn't issue you a payment that you're going to be unhappy with?
Shouldn't that argument be reversed, so that there's a perverse incentive for the insurance company then not to grant the claim, and then to wait until a jury trial, and then to be able to go back and argue that they only have to pay the lesser amount if and until you go back and actually replace it?
I would say no, Judge, because the litigation costs the insurance company money. And if they were to engage in that type of claim practice, there's the bad faith statute where they could be subject to punitive damages, state action. So the insurance company is highly regulated and they would not be able to pursue that kind of strategy. I see I'm into my rebuttal time, Your Honor, so I will sit down now. Thank you.
Okay. Counsel, you're recognized.
Good morning, Your Honors. Michael Cassell on behalf of the appellees. May it please the court. First issue I do want to raise that was not raised in the initial argument is whether the defense regarding payment of actual cash value needs to be raised as an affirmative defense. That was in our brief, and I believe it's tantamount to this court's analysis. An affirmative defense is something that admits that there is a cause of action, but seeks to avoid the liability. Here, the entire time that this case has been ongoing, or the lower court this was ongoing, the insurance company said there was no liability. There was no.
I read that in your brief. I mean, it looked to me like the homeowner's argument was, look, you got to affirm based on Universal's failure to plead those damage issues. Either I think it was a motion to eliminate, or some sort of motion for a directed verdict as an affirmative defense. But I mean, we're talking about damages. Isn't damages a basic element of a breach of contract? Does that really need to be raised as an affirmative defense?
Well, what we're seeking as actually, what we're discussing is a limitation on damages. And as counsel stated during his argument, it's absolutely a coverage limitation that they're seeking to enforce. So that kind of gets into the analysis regarding the type of policy we're discussing. It's an all risk policy. All risk policies mean everything is covered unless otherwise excluded. This is also a replacement cost policy where the loss settlement provision states that covered property losses are settled as follows. We will pay replacement costs without reduction for depreciation subject to the following. And then it lists all of these limitations, including the requirement to pay only actual cash value at the onset. So to answer your question, Your Honor, if the insurance company is seeking to limit those damages, yes, they must plead that as a defense. It is their burden to prove the depreciation in this case as a limitation to the policy. Under an all risk policy, the burden is first to prove that coverage exists by the plaintiff. The plaintiff has to show that there was a policy in effect as of the date of loss. There's no requirement to show that there was a specific type of peril which occurred, nor that there was any specific coverage provision that applied. It's just that a loss occurred during the policy period. After that is then the insurance company's burden to prove its exclusions or its limitations. And I would also note, based on the argument presented here today, that saying something is a coverage limitation immediately takes that out of the coverage provision category and puts it into the forfeiture or exclusionary provision category. Exclusion.
To that point, yeah, I had asked your colleague whether the loss settlement section of the insurance contract acted as a coverage limitation. What's the homeowner's position on that?
So the coverage portion of that provision is the replacement costs language. It says we will pay replacement costs without holdback of depreciation, subject to the following. After that, it's limitations. Because it's a limitation, it's tantamount to an exclusionary provision. And similarly, because the provision says that we will pay you the actual cash value until you do certain things, if those certain things aren't met, namely performing the repairs, then you forfeit a portion of the claim. That turns it into a forfeiture provision. It's not black and white that one section is coverage and one section is forfeiture or one section is limitation. Each sentence has to be read together, but each sentence can serve a different purpose. And frankly, with regard to the policy itself, when you're talking about coverage provisions, you're talking about, as counsel stated, provisions which provide dollar amount of liability. That's policy limits. That's the coverage provision. We will provide coverage subject to the policy limits for coverage A dwelling up to a certain amount. The replacement cost falls in line with that. We will pay the replacement cost of the loss subject to the following.
It sounds like the homeowners are taking the position that it was the opposite of what your colleague responded, which the loss settlement section is essentially a way that any money's paid, or that's just going to be simply how they're divvied up.
I don't know that it's simply how they're divvied up because it's subject to a limitation,
Okay.
subject to a reduction of an amount based on complying with certain policy provisions. That is inherently a forfeiture provision.
Do you agree with your colleague that the contract in this particular matter not really any different than in the T.O. Brito case?
I would agree that it's a standard homeowners policy with the same language as it relates to the loss settlement provision. Yes.
From your client's perspective, what's the defining difference as far as Manor House is concerned and Manor House's applicability to T.O.?
So Manor House is interesting. It's interesting that it's raised in this manner. I guess pun both unintended and intended.
I like a good dad joke, so.
Well, Your Honor, I can keep them coming. Manor House was against Citizens, and Citizens is immune from statutory bad faith. In Manor House, the court awarded extra contractual damages beyond that which were contemplated by the contract. I think in that particular case, there was no coverage for loss of use or rental income, something along those lines, and they were still awarded that as an extra contractual based on consequential damages being awarded. In this case, we're not seeking damages beyond the contract. The damages we're seeking, in fact, are contemplated specifically by the contract, the replacement cost damages without withholding depreciation, subject to the waiver of the limitation that actual cash value will only be paid at the onset. Here, of course, actual cash value was not paid because the claim was denied. And frankly, I don't think the fact that there was a denial of post-loss obligations versus a denial based on the cause of loss or an excluded peril matters one iota. It was a fully denied claim, and it was a breach of contract as a result. And we learn on our maybe first week of law school that when a party breaches a contract, they no longer can enforce the terms of the contract.
Should the court be concerned with if the court were inclined to, side with the analysis in Brito and T.O.? I mean, don't those cases kind of limit the ability of an insurance company and insurer to negotiate a contract by some of the equitable doctrines that are invoked in those opinions?
Well, I'm not sure I entirely understand your question, but I will note that there is no negotiation in an insurance contract.
Well, in Qureshi, I think the court really rejected the application of many of the doctrines like prevention of performance, right? Because the insurer didn't do what they were supposed to. They treated that as a condition precedent. And obviously Judge Warner dissented in that extent, but who got it right on that one?
So I will note that the prevention of performance is more of an equitable doctrine akin to the doctrine of good faith and fair dealing. It's if somebody shows up at 5:05 when the contract says 5 p.m. and the party locks the gates and doesn't allow them to come in, that's prevention of performance. Here, it's more akin to the Brito case, and even after that, the Weston case, which was the second case to come out recently in the second DCA. And the Weston case really spells it out very well. And they say that it's the insurance company is trying to say they want you to sue for ACV. They want you to then, if you win, resubmit a new claim, assuming there's no statute of repose or statute of limitations issue. Then if they breach, you can file another suit. And all the while, they want you to have done the repairs without any kind of guarantee of the coverage that was paid for under the policy. And specifically, the Weston case states, this approach places insureds in an untenable position of paying for what they contend should be covered by the insurer, and then hoping the insurer will have a change of heart despite repeated denials and reimburse them for their loss. Realistically, what should happen in a claim is an insurance company, and this is in line with FIGA v. Somerset, which is cited in my brief, the insurance company must determine both the actual cash value and the replacement cost value at the onset. Once they determine that replacement cost value, that's showing that they have assessed the entire scope and price of the claim. From there, they can withhold the depreciation, but the insured would then know what they are going to get reimbursed after they do the repairs. They're not leaving it up to guesswork. And if you look at the Brito case discusses it even further with regard to the separation of causes of action doctrine, where it states that the purpose of damages awarded on a breach of contract claim is to restore the injured party to the same position that they would have been had they not breached the contract. However, there's no allowance for a second bite at the apple. You have to bring the entirety of the claim as part of the initial claim. When you file a lawsuit, the damages are set in stone, and there's no second bite at the apple after the judgment. So the law presumes that a single cause of action can be tried and determined in one suit and will not permit the plaintiff to maintain more than one cause of action against the same party for the same cause. That's the Brito case citing to Mims v. Reed, 98 Southern 2nd, 498. That's a Florida Supreme Court case, which I believe is binding upon this court. To say that you can get to a final judgment and then you have to start the claims process all over again, and especially now when the statute of repose is limited to 18 months for reopened and supplemental claims, you're looking at, if you want to talk about a term that was used before, perverse incentive, the insurance company would be able to reject the claim, force you to litigation, and then claim later either res judicata potentially, or say that there's a violation of the statute of repose because you haven't presented the RCV claim within a certain period of time. So I believe that to force an insured to go down that path of uncertainty would be massively improper and inequitable.
But I know I'm going back to this, sure. in Qureshi, they relied on that 11th Circuit case, Buckley Towers condo. I mean, didn't they negotiate for that? I mean, this is a part of that insurance contract, is it not?
It is a part of the insurance contract, but it's not negotiated. It's a contract of adhesion. I will also note that Buckley Towers says two other things which were kind of ignored by the fourth. Buckley Towers first and foremost says that the court cannot add additional terms to the contract which do not exist. The other thing Buckley Towers said is the contract doesn't specifically require for the insured to submit a sworn proof of loss that includes depreciation. That's not in there. And that goes back to the argument that it's not the insured's job to submit a depreciation amount. That would be the insurance company's job as the party trying to assert the affirmative of their limitation. So to that extent, I mean, I think Qureshi is distinguishable here for a number of reasons. One, Qureshi was treated as a denied claim even though it was a covered claim. There was a payment issue. Two, the insured sold the property during that lawsuit and could not perform the repairs. So with that, I understand a little bit why there was an analysis that they couldn't recover depreciation because they never would have been able to do that. Now, on the other hand of that argument, if the insured originally obtained coverage and the insured originally performed the repairs based on the insurance company providing information that they would be reimbursed for certain things, they wouldn't have lost money in the sale of the home. But in the Qureshi case, they make it a point to discuss the policy has a diminution of value exclusion. So because there was a diminution of value exclusion, it didn't matter that the insureds lost money in the sale of the home. They ultimately sold the home at a loss at their own peril. I think this case where the claim was denied entirely, where the denial was maintained throughout the entire pendency of litigation, where the verdict form was not simply what are the damages, but rather 13-question verdict form, where the first was, did the insured meet their burden to show that a loss occurred during the policy period? And questions 2 through 12, all related to exclusionary provisions. There's no equitable way to force an insured to then proactively reduce their own claim only so that they can potentially seek a second bite at the apple and a new claim and then have to start all over again.
So along the lines of the denials, Universal's position is, look, this isn't a denial that, hey, we're not covering this. A lot of the denials were related to post-loss obligations, right? And indeed, TO, Brito, not the same type of post-loss obligation issues involved in those fact patterns. How does that impact the argument?
I don't think it does impact the argument. There's a plethora of case law that discusses post-loss obligations and denials of claims waiving the ability to rely on those post-loss obligations. There's also a ton of case law that discusses whether the prejudice analysis that's required. And what Universal is trying to do here is they're trying to make the loss settlement provision, which, and I haven't had a chance to discuss the ambiguity, or I'm happy to if your honors would like, but they want to make the loss settlement provision into some pseudo post-loss condition provision. In order to do that, there has to be a determination that there's been prejudice, because the jury affirmatively determined that there was no violation of the policy conditions, first and foremost. So Universal got that wrong, but they did that at their own peril because they denied the claim. And they never once claimed the loss was covered. They never once claimed that the cause of loss was covered under the policy. In fact, of the 4 defenses they raised, one of them was regarding conditions precedent. 2 of them were related to the loss having been caused by excluded perils. So just because they denied it for some reason, and I know they make a note of this in their briefs, Universal said, well, we had the savings language in our denial letter that we didn't waive the right to assert additional defenses. They were claiming in this case that the loss was an excluded peril. The other thing they were claiming was fraud. They accused my clients of material false statements and sought to forfeit coverage on that behalf. So couple all of that together, they never once raised that the damages should be less than what were sought. And that's something that does need to be asserted, specifically because it's based on a limitation in the policy. With regard to the issue of the loss settlement provision being ambiguous, I think during the initial argument, your honors noted that it only relates to covered property losses. And I believe that's true, but what it says is covered property losses are settled as follows. And there are 2 different potential definitions of the word settled. There's the word settled meaning to pay, and there's the word settled meaning to come to an agreement. I'm sure your honors have seen many cases where we talk about motions to enforce settlement. Those are based on agreements that are reached between litigants. A settlement here, if you insert the definition of pay, or if you insert the definition of come to an agreement, both can be true. Therefore, there is an ambiguity, a latent ambiguity that only applies when you address the facts of the case to the policy itself. If there's a requirement for there to be an agreement for the loss settlement provision to come into play, and there is never an agreement, then the loss settlement provision never applies. And that's why we have lawsuits. That's why we have breaches of contract against insurance carriers. If there is an agreement to the amount, there's not going to be litigation. If they—
It sounded like your counsel was actually suggesting that the covered loss provision can include all the way down the road when a jury determines it's a covered loss. What do you say to that?
Well, I say that the breach of contract occurred likely 2 years before that moment, and therefore there's no way for the insurance company to say, okay, well, we got it wrong, so now it's actually a covered. The insurance company still doesn't agree that it's a covered claim. We're here. If they agreed to it, then we wouldn't be here.
Yeah, so doesn't it have to be kind of be the payment definition? Because I don't think agreements to agree are enforceable. Right? I don't think you can have a contract that says we agree, we'll agree later to something.
I don't think this provision says we agree that we'll agree later. I think it says that once we agree, this is how it's dealt with. And there's the lost payment provision, which counsel discussed as well, which is it has 3 different provisions. It has whether an appraisal award's been paid, it has to be paid within 60 days, whether there's been a judgment, or whether there's been an agreement reached. So the agreement reached is part of the lost payment provision, which ties back into the lost settlement provision. You have to look at the policy as a whole and read all of the operative language together. So there's a provision that says, when we come to an agreement, we will pay you within a certain number of days. There's no set timeline in the lost settlement provision, but the lost settlement provision comes back to the lost payment provision in that when there is a certain element met, that there's been an agreement. Actually, I think the lost payment provision says, and I can double check this. I don't believe it's been discussed in the briefs, but I believe the lost payment provision actually says when we've reached a settlement. So if the lost settlement provision discusses a settlement, and the lost payment provision discusses the timeline that payment has to be issued when a settlement has been reached, then looking at those both together, I would say maybe there isn't an ambiguity. Maybe it actually is just the policy is clear. There has to be an agreement for the lost settlement provision to come into play. With regard to the Well, actually, your honors, I believe I've made all of my arguments. If your honors have any further questions, I'm happy to continue. If not, I'll yield the rest of my time. All right, thank you, your honor. So with that said, the appellees request that you affirm the final judgment, all interlocutory orders below, and remand this case for final judgment in favor of the appellants.
Counsel, you have 4 minutes and 18 seconds remaining.
Thank you, Your Honor. I want to start with the loss payment provision. It was just mentioned by counsel. And that provision says loss will be payable upon the earliest of the following: 20 days after we receive your proof of loss and reach a written agreement with you, which didn't happen in this case, or 60 days after we receive your proof of loss and there is an entry of a final judgment. So this contract between the parties specifically contemplates that a dispute may have to go to a final judgment. There's nothing in the contract that says if it goes to a final judgment and the jury sides with the insured, that parts of the policy disappear or get deleted. It's not in the contractual language, and it's not in the Florida Supreme Court precedent anywhere. To go back to the statute 627.7011.
Before we jump away from
Yeah.
that, one of the arguments that was being made was related to the interpretation of the word settlement. So, you know, let's say there was an ambiguity with that term. I mean, wouldn't cases like US Fire Insurance require us to say, look, we've got an insurance policy here. If there is an ambiguous term, we got to find that in favor of the homeowners. What's Universal's take on that term settle?
Your Honor, that term is unambiguous, as is the rest of this policy language that we've been discussing. And Qureshi reaches that particular conclusion. It says here, the insurance policy is clear and unambiguous. The insureds are not entitled to the repair costs unless and until work is performed and expenses are incurred. And that's really throughout the case law. There's a Florida Supreme Court case called Sabalo that says where there's a provision about work is performed, expenses are incurred. It's unambiguous. It means the work has to be performed before that is triggered. So there's nothing ambiguous here about the word settled or any of the other provisions in here. They work together to say that you get actual cash value unless you've made the repairs. And you can always certainly take that actual cash value, even if you get it from a jury, and you can use that to start making the repairs. And if those repairs are made and now you've run out of money, you go back and you seek the replacement cost value benefits and you complete the repairs. There's nothing here that would require this court to say the insured has to make all the repairs 100% full RCV work before they can get any payment from the insurance company. That's not what the argument is. So to go to the statute, the 627.7011 subsection 3, where it says in the event of a loss for which a dwelling or property or personal property is insured on the basis of replacement costs, that just means that it's a replacement cost policy. That's not imposing a requirement that the insurance company accepted coverage for the claim at the outset. And it's also important to note that the Brito decision was based on the determination of the insurance company pre-suit that the loss was not covered. And as a result, the second DCA said, well, loss settlement provision does not apply. The loss was not covered. We don't have any determination here pre-suit by Universal that this loss was not covered. We just have post-loss obligations. You didn't give us what we needed. This was a late reported claim several months later, and we didn't get to inspect it until even months after that. So the post-loss obligations were significant, and it's very different from what's in Brito. Additionally, if the ACV provision can be stricken from the policy, then where does that argument and rationale stop? Because you can make the same argument about the policy deductible, which in a hurricane claim can be extremely large. It's going to prevent repairs. The insured has to come out of pocket. Are we going to strike that or the policy limits? And that sort of shows the absurdity of the argument if it's taken to the extreme on the plaintiff side. And it would make it impossible for insurance companies to set premiums. If they issue a denial of coverage, how do they know 2 years later a jury is not going to say, hey, you were wrong, and now it's a completely different insurance contract that they didn't charge a premium for?
But on the flip side of that coin, I mean, this is brought up, I believe, in Brito. I mean, when an insurer denies coverage, isn't it kind of a useless act to require the insured to try to make the repairs when they don't even know if they're going to recover on that?
At that point, they wouldn't have to make the repairs to claim ACV, because to get ACV, you don't have to make any repairs. So if the insurance company denies coverage, the insured can sue the insurance company to determine coverage and then to collect ACV. And then if they choose to use that money to make repairs, they can get the RCV. There's no requirement to make repairs at the ACV. It's just the property that was directly physically damaged, and they could take that money and pay down the mortgage, or they could take a trip with it. We want to encourage the public policy of making repairs, and that's why there's that extra requirement contractually and statutorily to get RCV. So thank you, Your Honors, and for the reasons in the briefs and argued today, we'd request that the court reverse and remand.